Welcome to Case by Case. This is a podcast brought to you by Calum Jane and Luke Sadkovich. How are you, Calum?
I'm very good. We are slightly burning the midnight oil on this one.
We are. Well, we've had a busy week. We've had a very busy week. We've been in Europe on Monday. We're back for a client event here, which we held underneath our offices on Tuesday. And tomorrow, very, very excitingly, we're off to Vienna for our global retreat.
The firm retreat, looking forward to it, catching up with the Vienna team, the Chicago team, the New York team. It'll be a good weekend.
Getting everyone together. We try to do it, every 18 months, 2 years, and the idea is to get the whole team together, support staff, all the lawyers, and kick around some ideas, make sure we're doing well on integration and all of that, and roll out some global strategies as well as have a bit of fun.
Make sure everyone's subscribed to the podcast.
Exactly. That's the primary objective of the global retreat. So great. And look, I've got to say, I have had, and I think you've had as well, over the last few days, having bumped into clients in the flesh that we may not have seen for a little while, we've been getting some really good feedback on the podcast.
Cool, isn't it? And I would say, if you listen to it and you enjoy it, just because it's so nice to hear people that actually listen to this and they take something from it. Don't feel like you have to wait for us to see you in person. I would love it. I'd love an email to come in to say, I do listen to it. I do enjoy it. Honestly, it makes my day when people send that sort of thing through.
It does. And look, a few people have said that they actually use the podcast to keep up with updates, and for some of the junior people coming into the industry, they found it as a learning tool, which it's really nice and refreshing to hear that. We put a lot of time and effort into this, so we hope you enjoyed today's episode, and we're going to get into some shipping law. I don't know many people that would not have heard of the vessel, the Ever Given, which you all will recall was the vessel that got stuck in the Suez Canal.
And when this happened, this was one of those things where, for anybody who works in the maritime world, I suppose this applies quite readily to lawyers, perhaps in particular lawyers who don't have a kind of a family history in the maritime industry. This is one of those things where you can finally explain to friends and family the sort of work you do. You can say, you've seen it in the front page of the news today. That's it. That's the type of thing I do.
Exactly.
I get it now.
Exactly. I know. It was it was one of those events, quite a full-on event, of course. And the Suez Canal is such a lifeblood of global trade. So many vessels go through that passage. So it's not good when a vessel gets stuck and closes down the whole canal, cause a lot of problems. And there's a huge impetus on getting the vessel unstuck.
Yeah.
And that's what we're kind of talking about today. We're talking about a salvage company, Smit, that came in to the rescue, amongst others, to refloat the vessel. And this decision is all about whether Smit did that under an agreed contract with the owners of the vessel, or whether there wasn't a contract agreed, such that Smit, as a salvor that was successful, can claim under common law or the International Convention on Salvage. So a more open-ended claim. We'll get into the differences in what that means for the salvors and what they could recover. But that's the issue we're looking at. And just before we get into some of that juicy stuff, I will give the case note. As I mentioned, the claimants were Smit and related companies, and the defendants were Luster Maritime and Higaki Sankyo Kashi Limited, relating to the Ever Given. And this decision was handed down on the 30th of March, 2023. We're in the English Admlty Court, which is part of the High Court, and the neutral citation number is 2023 EWHC 697 Admiralty.
Did you notice on this head note? It was handed down at the Cardiff Civil and Family Justice Centre.
I saw that. And I didn't actually, my eyes saw it, but I didn't focus on it to think why.
It's unusual. I don't know why that. Maybe it was I don't know, maybe they just had the time to do with it. If you're listening to this and you're from one of the firms involved, then, and there is a reason, then be interested to hear.
I wonder whether it's justice related, in the sense that Mr. Justice Andrew Baker was on a circuit or something at that time, and I don't know, sitting in the Cardiff Civil Family Justice Centre, or maybe there were repairs to the Rolls building. I don't know. So yeah, it was only handed down March this year. It wouldn't be COVID related or anything like that.
But it's interesting. Really, fundamentally, there are all sorts of fabulous facts around this one, and it's an issue that the world knew about when it was happening. You've got as you say, everyone knows about the Ever Given. Fundamentally, here is a question, a really basic contractual question. There are significant complexities to it, but it's one of the most fundamental questions under English contract law. It's contract law 101. Was a contract concluded or not?
Yeah,
and we see that not infrequently. This just first principles question comes before the court quite a lot. I'd say we see this at least a few times a year in different guises, whether it's subject cases. We've seen a spate of them through the last couple of years, or in this case, a salvage contract. And it's always interesting to see those kind of core principles around contracts law in play.
Yeah, absolutely. And you're right to kind of identify that at the start, because when you read a decision about the Ever Given, you are awaiting these types of decisions with a lot of enthusiasm and what it's all about. But actually, this is a pure contract formation case, really, and all the facts that go along with the rest of it, and the vessel and what happened to the vessel, in many ways is kind of a sideline to the real issue. What we're looking at here, the communications back and forth between the parties, what they said to each other, emails they sent back and forth, and whether that created a contract or not. And for those of you who know contract law quite well, you'll appreciate that there are various facets or elements to forming a contract. You need offer, you need acceptance, you need consideration. And importantly, you also need to have the intention to create legal relations, the intention to be bound to the contract.
And in particular, narrowing in even further, what this is about is how you have to evidence that intention in a situation where you're agreeing core terms with the understanding that there's going to be a full document created at some period after those core terms are agreed. So you're not in a situation where you're trying to show that you have intention to be bound, in the sense of we had all the right terms, everything was agreed, but did we intend to be bound to it? You're looking at a situation where you can have these kind of heads of terms, if you like, against which there's going to be a full contract produced in short order. And the question is there an intention to be bound to those sort of heads of terms?
Yeah, exactly. And before we get into some of the specifics of the case, as we often do, we like to touch on a bit of procedure, a bit of how the case played out, some of the issues that pop up. I often, you do the same, Calum, but I often focus in on little comments by judges on how the parties have pleaded their case, how they've argued things, how things have come out, how, the pleadings may have changed come the time of argument, how barristers or the advocates are reshaping the arguments as they're talking about it at court. And we have a bit of that here. Yeah. We have quite a bit of that here. The judge picks up on some of the, let's say, whether deficiencies is putting it too highly, but some of the issues around how the case had been pleaded, and whether the pleading was sufficient to actually make out formation of a contract in and of itself. And the judge was almost like prodding counsel here to say, well, hang on, can you give me a bit more of this to explain how you say you get to, on the material that's before me in the allegations as pleaded, you actually get to a properly formed contract.
Yeah, and there are a couple of practice points in this one. Maybe you take that one. There are a couple of other things that caught my eye. In particular, and it goes to the type of contract, this type of dispute. It's really important. I mean, this goes right back to kind of the law school basics, but it's really important when you're having a dispute over a contract. What you're looking at is an objective understanding of what the documentary evidence says. And if you're providing witness evidence, then that cannot be a commentary on one witness's view of what the exchanges said. You can give witness evidence to say, well, at the same time as that email was sent, there was also this conversation that happened by phone. And that's proper witness evidence. But you can't give witness evidence that says, I sent this email and I meant this, because it's not relevant. What's relevant is what the email, the wording of the email suggests to an objective person with the parties intended. There's a really nice, I actually thought it was almost Hemingway-esque line about the witness statements in this judgment, where Mr. Justice Baker said, none of the witness statements was particularly long. Even so, they were all longer than they needed to be. Yeah. It gives a real nice, without saying too much, it gives a real sense of the length of those kind of witness statements. The sort of 5-6 pages that just there's a lot of, you can imagine exactly what those witness statements contained. Each party wouldn't have wanted the other party to control the narrative on what was meant by the parties. I'm completely confident that the lawyers involved on either side knew when they were submitting the witness statements that they were touching on things that were a little bit, irrelevant, and maybe they kind of expected a sort of slap on the wrist from the judge. But you just don't want to be silent when the other party is trying to dictate the narrative. So you feel like we have to put something into it. You can see all this coming through in that very short snippet.
I'd picked up on this one too. I'm glad you brought it up, Calum, because we recently had a case which we handled on the New York side. It was an ICC arbitration, all about, quite similar in a way, nothing to do with salvage, but it was a commodities contract where there was an exchange of emails, and the question was whether that was enough to have created a contract when the parties said in this exchange of kind of main terms, I suppose you'd say, that a full contract would be drafted thereafter. And the question was, was that enough to create legal relations or the full contract? And the arbitrator, who I won't name, but the arbitrator in that case, it's now finished and we've gone through to an award and thankfully prevailed on that one. But the arbitrator, when we were cross-examining, and as I say, we were doing the advocacy ourselves on that one, the arbitrator picked us up a couple of times and said, well, look, I'm not really interested in what this witness has to say about whether a contract was formed or not. The witness's opinion on whether a contract was formed is really irrelevant.
Yeah.
It's an objective assessment, looking at their conduct, looking at what was said. And I like this phrase as well that Mr. Justice Baker repeats a couple of times about what passed over the fence, what crossed the fence. It doesn't matter. And this is another kind of area where when you're putting together witness statements, witness evidence, you can kind of drift into focusing on what was said internally about subjectively what your client may have thought or the other side may have thought about the state of the contract. It's not relevant. It's what crosses the fence, what you say to the other side. And then you judge that conduct, that language, what was said, written or orally, to see objectively whether a contract was formed.
One of the ways in which it may be relevant, and you may want to adduce evidence on from the people who are involved in the contract, or more likely from experts, is if you're trying to go as far as saying that actually in this specific type of circumstance, there's an assumption that things are done in a certain way, and you're pleading an argument based on custom. But sometimes you see a kind of attempt by the back door to use a custom argument to get in some evidence that is actually not strictly relevant. And interestingly, taking a similar kind of example from practice, we had a case recently where we were actually very, very confident that there was an established custom in this case around the way that the document should be interpreted. And even so, even at an early stage, the tribunal, very, very experienced tribunal, kind of sent a message saying, you're welcome to plead your evidence on the custom of the trade, but we do recognize that it's a very high bar. So that, the tribunal was immediately sort of saying, don't use the custom argument as a way to give us irrelevant evidence. And so it's something that judges, here is completely all over this point. The relevance of the witness evidence is really questionable, and whether it's irrelevant when the witness is providing commentary on their own documentation. What matters is what the document says, and as you say, whether it crossed the fence.
Yeah, and let's get into some of the exchanges in a moment. Because I'm conscious we're probably doing too much on procedure this time, but I couldn't help myself. I do want to make another point on pleadings because I think this is a really important point, actually. So what happened was there was an exchange of emails, discussions from the 23rd of March through the 26th of March, 2021. And that's really the kind of key set of correspondence. And we probably should read out some of these and go into some detail. But what was pleaded was that the agreement was formed on the 26th of March. It was quite a specific pleading relating to one day based on the final exchange, if you like, that was relied upon here. However, in the days leading up to that, including on the 23rd of March, there was a statement that said, or an email that said, it was agreed between Captain Sen and Mr. Weiss that Smit would charge for personnel at usual scopic rates. Now, that when I read that, I'm like, well, hang on, they're already agreeing something here orally on the 23rd of March. So why isn't there a pleading? And this is what the judge is saying here. Why isn't there a kind of a fallback pleading to say, well, between the 23rd, the 24th, 25th, and the 26th, this culmination of telephone calls, emails, and of course the exchange on the 26th of March also could be construed as a contract being formed. They were very specific. And then what happened was during cross-examination, the QC who was on for the owners here started cross-examining on this point to open up the argument in closing to say, well, in the alternative, if a contract wasn't formed on the 26th, it was formed orally or through the other communications earlier. And of course, the counsel for Smit picked up on that and said they're prevented from making that argument because it's not pleaded. And the judge was with them on that. The judge goes on to say, well, even if they had pleaded, it wouldn't have persuaded me. I didn't think a contract was formed anyway. But it could have been. Here, the judge said it wasn't determinative, that pleading failure, but it could well have been.
Yeah.
It's such an important point.
And there is some good practice here by the salvors lawyers in the pleading stage. So it looks from the judgment as though they put in a request for further information on exactly this point. So not only was there the fact that this wasn't pleaded in the defendant's defense submissions, but even beyond that, the claimants then sent a request for further information saying, are you saying that there is only a contract formed on the 26th of March and not any other time? And the defendants respond saying, yes, that's our case. And it's, I've made a note to myself here that you have to be so careful with these requests for further information because, this is...
Yeah, well, they say it is. Their response was that they do not rely on any legally binding contract concluded on 24 March.
Yeah.
The defendant's case is as pleaded in the amended defense, in particular paragraphs and so on. So, yeah, you're right. They kind of tied them up in it. And then from there, they had nowhere to go on this other argument. As I say, the judge wasn't going to be persuaded by that fallback anyway, but it's an important pleading point because it could really trip someone up on in a different case.
And quite a nice piece of lawyering.
Yeah. So on the law, as we said, this is not one where, and again, another nice line, there was no material dispute about the principles, in brackets, in truth, the principle to be applied. So it's not a case where we need to get into a detailed analysis of the law. We are looking at the contract formation issue being the intention to be bound.
The one thing I would say there, and I'm interested in your take on this, is, and we'll get into the individual exchanges that crossed the line, and even those that didn't. But one thing that wasn't clear to me. Okay, so the way the judge approaches this is that you have this quote unquote agreement, which is reached on the 26th of March by an email sent containing what is said by the defendants to be the main terms, and then a response confirming that agreement. And the approach the judge takes is that because there was still a further agreement to come, it had to be very clear. It almost seems like it had to be more clear than normal that there was an intention for those initial terms to be a binding contract. Yeah. And in the law as it's set out in this judgment, I didn't necessarily see any particular higher standard. I can see that you have to make it clear, but and I'm trying to find...
Yeah, well, what you're looking for, it's an interesting point. I must admit, I didn't pick that up when I read through it. I thought the focus was on ambiguity or lack of ambiguity. So rather than kind of needing something that is clearer at that stage of exchanging the initial communications which reference a subsequent contract, what the judge refers to as I read it was not some higher standard, but that there was an absence of ambiguity, and that to conclude a contract, there needs to be a clear expression of what's being agreed. And there wasn't that level of clarity in these exchanges to convince him that, you might argue with that, but that's how I think the judge approached it.
I think that's right. And I think for me, the slight difficulty I have with that is, so if we get into this kind of alleged contract, and we'll start at the end of where the defendants say the contract was created. There's this email that's sent from the salvors to the defendants, where they say, we refer to our telephone conversation as agreed over the phone. Please to confirm the below. Owners agree to the following. The tugs, dredgers, equipment engaged by SA and the subsequent salvors are separate to the Smith's offer of assistance. There's a list of 3 plus 2 sub clauses that kind of set out this agreement, and then the response to that is "Thank you, Captain, and confirmed," which is very much appreciated. I shall inform our team accordingly, and we shall follow up with the draft of the contract upon receipt of your client's feedback to our draft. And the question there is, I suppose, how much clearer do they need to be that they agree these main terms? If they say "thank you" and "confirmed," they've got a reasonable, a pretty clear kind of main form of agreement, and the response is "thank you, that's confirmed." There is still definitely the second contract to follow, but on those initial terms that are set out, to me, there is a clear agreement to those terms. And the way that I felt this was approached, and this may well be the correct approach, but the way I felt this was approached in the judgment is that because there's a recognition that there's going to be a follow-up contract, both parties acknowledge that they actually haven't agreed all of the details. There's going to be a second contract. It almost felt to me like there was a presumption that the confirmation on the main, the agreed main terms was not a confirmation that was intended to bind the parties to those main terms, unless it was kind of specifically clear that it was. It's almost like it has to be slightly more clear than normal. That you can't just say, "Here are my terms." If if we ignore the fact that there was a separate contract to be agreed and somebody said, here are my terms, A, B, C, and the other person turns around and says confirmed, then I think we'd have no real issue saying, yeah, that's contract under English law. You've set out your terms, they've confirmed it with no reservation, that's contract. But here you have the fact that there is a bigger document that still has to be agreed seems to create this sort of presumption that you need to do something more to make it really clear unambiguously. And there's a lot of reference to this in the agreement that has, we're looking for clarity, we're looking for a lack of ambiguity, that there's a really clear intention for the parties to be bound at that early stage, even though both parties were aware that there was more to do on the finer details of the contract.
Yeah, I see that. And when I first read these exchanges, my initial impression was, well, this is pretty close to a confirmation, isn't it? These are the main commercial kind of terms that a salvor would set out to agree with an owner. They say, we look forward to your confirmation. The response is, thank you, Captain, and confirmed, which is very much appreciated. So, you have language that reflects what was requested, a confirmation, and you have a response saying confirmed. The language that then refers to, the subsequent agreement or the actual agreement is the first message is, we can then start ironing out the rec hire draft agreement so that the same can be signed at the earliest. And the response to that, if you like, is, we shall follow up with the drafting of the contract upon receipt of your client's feedback to our draft as sent last night. Now, I've got to say, when absent this decision, if I saw those two together, I have some sympathy here for the owners, because when it says we can then start ironing out the rec hire draft agreement, to me, ironing out is the kind of phrase you use, like smoothing out or, finessing, or, it's not the language you use to agree on critical terms, if you know what I mean. Yeah. Like if I was trying to understand like what a commercial person meant by that, I would think that it's going off over the nitty gritty. And yes, that's the kind of thing you deal with in a main contract, but we've got our head terms agreed, so we're sweet. We can crack on. And that's the kind of thing that, going back to that commodity contract example, where you might have the 20-page commodity S&P contract, but the actual essential terms are agreed much like this within about, 8 to 10 bullet points.
Yeah. And it's completely possible under English law to do that. You can agree core terms with a separate agreement to follow. That's that's made clear in the judgment too. They quote Goodwood Investment Holdings against Thyssen Group, which says, in brief, it is well established that the whole course of the parties' negotiations must be considered, that it is possible for the parties to conclude a binding contract even though it is understood or agreed that a formal document will follow, which may include terms which have not yet been agreed. And it goes on, and that whether this is what the parties intend must be determined by an objective appraisal of their words and conduct. And I have to say, I think this one is on the wire. It could go either way, and if what we're looking at is an objective appraisal of the parties' words and conduct, and the parties' words and conduct are to set out clear parameters and then to respond confirmed. We'll get on with the other document. I think that's pretty close to an agreement, with an intention to create a further document.
Yeah, and that was my initial impression when I read this. When I read those exchanges, right? But as you go through the judgment, what becomes clearer when you look at the other communications leading up to this exchange, and this is really where the court went with it. It was about, what was this confirmation about? What was it seeking to achieve? And without going through every single message and conversation, effectively what the judge was saying was that Smit was looking for some kind of assurance that negotiations were continuing such that they could go ahead and send their crew out, incur significant out-of-pocket expenses, and start the salvage operation. And from their perspective, from the salvors' perspective, they didn't need a contract to be formed to go ahead and start incurring those costs, because they could always fall back on the common law or international convention. So they had, as long as there wasn't an authority point, they had the ability to fall back on good claims for their services, particularly if they're successful. And what this did, in the judge's opinion, was provide some sort of comfort, some sort of assurance that negotiations were progressing, and that was enough for them to go ahead and carry it on. But I'm not sure that completely gels with especially the exchange we've just read through. But that was the point.
Yeah, and there is some force to it when you go through all of the all the exchanges in the days leading up to that 26th of March exchange. There is a sense, at least it comes through in the judgment, that there's a sense that what the salvors needed was some indication that they were still properly discussing these, and when the agreement was reached, they were going to be the core terms were going to be the ones that they'd already set out, but that it was subject to this further agreement. I do think it falls quite in the balance. There were all sorts of arguments that were raised, as you'd expect, by the defendants who were trying to argue that the contract was in place, and they are all dealt with by the judge, and in quite a nice way from kind of paragraph 73 onwards. They dealt with in a few lines each. We can go through a few of them, but obviously, if anyone listening wants to really have a look at where this case turned, then that's a good place to start. But there were a few of these, a few of these arguments that I think maybe had some better prospect of success, or maybe were more forceful than they were given credit for.
Yeah, the first one is this point about the implications or ramifications for how the salvage industry operates if the salvors here are correct. And this is a personal opinion on this, but these types of arguments to me, and a colleague of ours, I'm sure he wouldn't mind me mentioning it, but Aidan and I have discussed this before, where these type of almost policy reasons don't really wash. I just find them not that convincing. And it's interesting that the judge decided to take that point first, because I don't know if that would have been the first argument that would have been run. But that if the salvors were right here in the way that they were able to say that there wasn't a contract in place, that would then have all these consequences. It feels policy. It feels, I don't know. What did you think about that one?
It leaves the door open to the court to say, well, look at it the other way. There's a policy benefit to this being certain. There's a policy benefit to requiring the parties to actually put down their terms, or make it very clear that they want to agree a contract. So policy was almost too easy to argue on either hand.
Yeah.
But I did think the second point that they raised, the second point which the order was dealt with, I thought that was quite a strong one, which is, and this goes more to the construction of the exchanges. And here the salvor was basically saying, look, unless we get this agreement, we're not going to do any more work. That's it. We cannot work without this agreement on these key terms. The argument from the defendants, again, the defendants are here are trying to say the contract was agreed. The argument from the defendants is this is good objective evidence that the parties did intend for this to be a contract, because if they didn't, then there's no point in there's no point in the salvors threatening to down tools. if the salvors were giving that kind of ultimatum, then it meant that it was really important to them to have these terms agreed, and therefore those terms were clearly intended to have contractual force. Otherwise, why would they care? And the judge's response to this is that he says the argument assumes without foundation that a salvor in Smit's position would regard agreement in principle on important main terms, and thus progress in the contractual negotiations, as worthless and insufficient to buy a decision not to pause their efforts or stand down more generally. And I think there's something to be said for that.
Are you convinced by that?
Nah. Honestly, not really. Mm-hmm. I don't know how it fits with the general policy principle that he says, when he's talking about the policy above, about how it's really important to be clear on all these things. Yes, I agree with that. But at the same time, I just struggle with how much more clear you can be in the cut and thrust of these exchanges. These points are really important to us. We're not going to do any work until these things are agreed. And then the other side says, okay, I confirm them. And then off they go to work. And then they turn around. It happens that obviously they manage to refloat the ship. That gives them a far greater claim in common law, under common law salvage principles than they would under this agreement. So they turn around and say, well, actually the agreement doesn't exist anymore. Or the agreement never existed. But it feels to me as though they were saying, we're not going to do any work until we're sure we're going to be paid for it. We're not going to do any work until you make progress on negotiations.
But isn't that the point? Like that's why I struggle with this one. It's almost like when you make an ultimatum, you're trying to get something, right? You're trying to put the pressure on the other side to agree or to concede or to do something. And in a high pressure environment like this, when we're talking when hours makes difference, when this is on the front page of the newspaper, when the sailors want to get out there and win the job and get their kit out and working, their people onto the boat, are they really looking for some assurance or comfort that they're going to continue to have negotiations? And these are just, I don't know, this is like the framework of what the negotiations are going to be. And yes, we'll then have a full contract. Is that enough to go ahead? Maybe it is. Maybe it is because, let's think about it from another perspective. Salvage is a competitive landscape, right? There are other salvors out there getting underway, becoming the salvors that get the gig. That's an important commercial imperative from a salvor's perspective. Another salvage company could have been trying to get there. They maybe got wind of another one, they want to get out there. So they actually just want some type of, assurance that they're in the running. They've got the lane. They're going to have the negotiations. But I know I'm creating other policy arguments here on the fly.
And I agree with you. And I would agree with you, except for that's not what they've asked for.
Yes.
They've not asked for an assurance that negotiations are going to continue. They've asked for some very specific points around remuneration. So if they said, we need to see some progress in these negotiations, we need to see that you're interested. We want to finalize the contract, but we want to be sure that we've, that when this contract is going to be on these terms. Again, maybe that is what they're agreeing. It's close.
It's close. I know. I'm with you. And maybe is this why? Like coming back to the pleading point that we're talking about, is this why there was this focus on the 26th and only the 26th? Because when you look at those two messages in isolation, it does look very much like a contract. Yeah. A basic one, but a contract. The issue with it, I think, is, and one of the points picked up here in the decision, is it's not entirely clear from that exchange what the services were going to be that were performed. Now, the salvors say that was open. That was, any salvor services, and they had to express that again as a part of the submissions. But I don't know. I just I wonder whether that was part of the strategy in making this all about the 26th and not looking at the lead up, because when you look at the lead up and some of the other communications, that's when it does become a little muddier.
I think that might be right. And so one of the other arguments I'd like to just pick up on and this is maybe, again, just to pick up on one of the more controversial ones, because I think that a lot of the arguments were actually pretty poor and disposed of well by the obviously by the claimants, but and as reflected in the judgment. But there's this argument that there's no attempt to say this agreement is subject to details or subject to contract.
I knew, just to interrupt you, I knew you were going to pick up on subjects. It's one of Calum's favourite topics, subjects. I don't know how many cases you've had now with subjects. Whenever it comes up in the office, it's like, go have a chat to Calum without subjects. Anyway, keep going.
Because it's a really interesting crossover between things being agreed commercially and the way that the law treats these subjects. And we can and will go on about subjects on another day. But only here to flag it, because in previous correspondence in the chain, they did have this subject to contract wording, and then they removed it for this message, right? And maybe that doesn't signify anything, maybe it doesn't. But this was something that the defendants relied upon. They said, though, clearly at this stage we are looking for a contractual relationship because we've removed the subjects, and we could very easily, the salvors could very easily have put in their message subject to details, and they didn't. And the judge says they didn't say subject to details, but the judge says that was, however, the effect of what was said in the key exchanges between the parties. The consensus alleged to have been contractual was created by Captain Sen's email and Mr. Jansen's reply. The nature and effect of the offer was made clear by how it was articulated in the effect of an acceptance. We look forward to your confirmation, and then he's emphasized the next bit. We can then start ironing out the rec hire draft agreement. So the judge's view is that even though it doesn't say subject to details, it was in effect subject to details because there's a reference made to the rec hire draft agreement, i.e. the longer form contract. But I'm just not convinced by that, because we're in the realm of an agreement on core terms, and all the parties know that agreement is subject to not subject to, all the parties know that there will be a further agreement on the longer form. So in that context, does a reference to the longer form agreement mean necessarily that it's subject to the longer form agreement? I don't think it does. I don't see why it would. If the parties all know that this longer form agreement is coming, then simply referencing the fact that they've got to iron out some wrinkles in it doesn't mean that what they've said above is subject to those wrinkles being ironed out.
The language here, for me, does not have the flavour of contingency. It doesn't. This is what I was saying before. We can then start ironing out the rec hire draft agreement. Ironing out an agreement is massaging contractual language. It's the kind of like the analogy I would draw is when the commercial teams of two companies get together, and however they do, whether it's at the bar, around a negotiating table, whatever, and they map out the main terms and they strike a deal. They shake hands, celebrate in whatever way they celebrate. They then say, okay, let's get the lawyers on to work up the contract. We've got a deal. We're locked in. We're fixed. Yeah. Right? Let the lawyers iron out the draft agreement. Like, that's the language that you would use. It's not, we look forward to your confirmation, which will be insert some other language for subject to finalization and execution of the final agreement, right? That, I don't know. It's just my take on it. It's close. It's there. And obviously,
yeah. And also, we're focusing here on the points which are more hanging in the balance, right? There are other arguments, and there are 8 of them, and we've hit on 2 of the ones which I think you can flag as being the closest. But you're right. It doesn't say we look forward to your we look forward to your confirmation. It just doesn't say that this is subject to the details being ironed out. It says we have to iron out the details. But I mean, the irony in all of this is we're talking about how ironing out the draft agreement suggests very minor amendments. The truth is actually there were quite major amendments. True, but that was 2 days after this agreement either happened or didn't happen.
Well, that's true. That's true. I'll give you that. And you know us, we always like to kind of stir on these things anyway, and when there's the sniff of an argument that we could make the other way, we'll give it a good crack. And look, there's the point that we made before about that there were some really interesting comments actually internally within the parties about whether there was an agreement or not, but they were largely said to be irrelevant. And I think that's you're smiling again.
I know they're not relevant, and I know that they're not strictly, they don't go to the interpretation of what was said on the 26th of March, and I know we don't hit this custom of the trade, but I'm laughing because the message that was sent internally at the salvors after they have the confirmation, so the salvors set out their kind of 3 points plus a couple of sub points that they say these are really important. We need these to be confirmed before we start work. The other party come back and say confirmed. Let's iron out the wrinkles in the full agreement. And the message that goes back internally with an exclamation mark is agreement on main terms. That's, obviously they sat there thinking, great, we've got the go ahead, we've got the gig. They've agreed to pay us this amount. They've agreed something. There's no sense internally that they think, oh well, let's make sure we really focus on getting these terms drafted up. And this is, I suppose, this is also why I like subject cases. There's just this, there's an uncomfortable relationship around contract formation under English law, and I think the way that commercial parties understand contracts to be formed.
Yeah, I think you're right. And it goes back to what we were saying right at the outset about clarity and ambiguity. And there seems to be a trend, at least with some in the court, that they want to see clarity in contracts. And in the absence of that clarity, commercial parties are going to be knocked around. Not always, but that we've seen it before. And you're right, because what's interesting about this statement that you just read out, it's agreement on main terms. So, it's a distinction. They're actually internally making the distinction that they've agreed on main terms, and yes, there's other stuff to do in the full contract. It's not, oh great, they've agreed to negotiate where
exactly. It's not, let's, we can get our draft out now. It's there is agreement on these points. And I think that this is, we're being deliberately provocative, and we're finding the points on which this case, really turns, and it is a really interesting case. I think we do so with absolute respect to the court and to Mr. Justice Andrew Baker.
And the parties arguing it.
Exactly. And these things are close to the wire a lot of the time. That's why it's so interesting. That's why it's such an interesting discipline. But I think that in some respects as well, the judges' hands are slightly tied by the way that English law approaches these contracts. As you say, there's almost this move in these contract formation cases towards really wanting to see clarity, and that's not something that you necessarily always get in the maritime industry.
Yeah, I agree. It's a balancing act. It really is, between supporting commercial parties and how they do their business, and upholding agreements where the parties think that they've formed agreements, versus whether parties have objectively formed agreements, and creating a consistent, coherent body of law which allows other parties to know where they stand. So if they want to form an agreement, these are the rules. These are the principles that should guide you. Okay, cool. What about this urgency versus unambiguity point? Did you look at that one?
I did, and I think this is one where I'm with the judge.
Yeah,
I think that if you say there clearly was an intention for a contract to be bound because it was urgent and therefore things can be a bit sloppy, I just don't think that works. Urgency is too woolly a concept, and the primary point has to be, did the parties clearly show an intention to be bound? And if the answer to that is no, but they were under time pressure, it's not really a good enough answer. I think it has to be, even if you're under time pressure, you can't just say that I suppose everyone's under if someone's under time pressure, everyone's under time pressure. So there's no reason that one party should be favoured over the other simply because urgency existed in the situation. You still need to be clear on what's been agreed. And I think that they were clear on what was agreed, but I don't think the urgency is if the judge is not satisfied that they were clear on what they agreed, then I don't think urgency is a reason to get them over the threshold.
Yeah, I think that's right. And also, the nature of negotiating and agreeing salvage contracts like this is an urgent context. And not many. There are some, of course. There are some that is slow burn and what have you. But in a situation like this, it's going to necessarily be urgent, right? And both parties are going to want to put a contract in place pretty quickly and know where they stand. Owners know that because the owners are dealing with authorities, the local authorities, the Suez Canal Authority here will be on top of the owner saying what's going on. They'll want to know that salvors have been contracted. The salvors will want to know that they've been contracted and they've got the gig. They want to know the terms that they're on. Now, it's a neat argument. The reason why this argument arises is because in the absence of a contract, because the salvors were successful in a relatively short period of time, the outlay of costs that they had to expend on this salvage operation was a lot lower than what they get awarded under the International Convention and what they would have received had there been the binding contract on the figures. So it proved subsequently that this was a much better deal for them. But in many cases, they will want the certainty of a contract to know what terms they're going in on. Well, look, I've kind of got through most of the points that I intended to chat about on this case. I think my final remark on it is that we've talked a lot about the specific language in those key exchanges on the 26th of March, 2021. And that was how the defendants wanted the case to be run. That's how they ran it. Looking at a narrow exchange of emails to see whether a contract was formed across those two messages. However, the court noted, I think, if I can say with the greatest respect, quite rightly, that it's not just about those two exchanges in a situation like this. You've got to look at the conduct of the parties in totality at this time, what they said to each other, the other messages. And there are other messages in here that are much more equivocal and much more kind of, woolly around the state of affairs and what needs to happen. And there was this sense that the salvors just wanted to get out there and get the gig and get on. And that actually having the full agreement locked up wasn't super important for them to be engaged and to get going. So it's not, I think it's not right to just look at those two exchanges. You need to look at the context of the other message. And in fairness, we haven't gone through all of those facts here because it'd take too long. But
you're right. And I've just, as you've been saying that, I've just, been going through the judgment, and towards the end of this relevant part, the judge does say, that is, I consider the plain tenor of the parties' correspondence taken as a whole. When he's talking about the fact that this, across the piece, there was no agreement. And yeah, and you're right. It is no coincidence that the defendants had looked to the 26th in isolation and really honed in on that, because taking those in isolation does put them in the best position. And I do think it's a really good arguable case. And I think the salvors have got away with one here, not necessarily because I disagree with the judgment, just because they were pushing for this contract to be agreed. They thought it was agreed. They thought they had an agreement, and they're going to get a windfall.
As much on WhatsApp.
Exactly. and it turns out that actually it's not been agreed. And that's something that if you go back to the 26th of March and you were to say to them, actually, this is not agreed, they would say, oh, what? No, that's not fair. But then further down the line, suddenly it's actually quite helpful to them that that's not been formally agreed.
No, I agree. Yeah, it's one that we're seeing eye to eye on. And I think there's actually a nice loop back to the procedural points that we started with, in that it's not coincidental that the judge made a particular point to identify those pleading deficiencies, because what the defendants, what the owners were seeking to do here was to narrow the analysis to one day and two exchanges. And they didn't run an alternative argument based on the totality of the exchanges, which were relevant. You can't say that these exchanges weren't really relevant in trying to work it out. And I think the judge was very much like that. Maybe even that guided in a way. So, yeah, interesting. I really enjoyed this case. It actually didn't have much to do with the vessel being stuck in the Suez Canal in many ways. It's all about emails and telephone calls about whether a contract is formed or not.
That was a good one. I really enjoyed talking that one through. It was an interesting one.
Did we say we're going to do a short one today?
I think we did. It was going to be a 20-minute.
This was everyone listening in who's made it to the end of this podcast. Thank you. Number one, we love it when you actually hear me say these words at the end of the podcast. It means you've held with us the whole time. But two, this was our attempt at a 20-minute pod. So here we are. Well, look, thank you for listening in. Take care. Until next time. We'll be back hopefully next Thursday with our next episode of Case by Case.
Cheers, everybody.